immigration lawyer. In this live, I'm going to provide a brief update on any UK visas issues, including e-visas, and also provide brief answers to your questions on any UK visa applications, including EU settlement scheme, British citizenship, etc. Secondly, so before I start the live, just want to give an overview of what I will be covering. So anyone can come live and ask your questions. You need to be a subscriber. You can subscribe just within a minute. You can ask a question. If my voice is not very clear, please let me know. If my voice is fine, just give me a thumbs up. Anyone comes live, just give me a thumbs up. So it's okay. For the last 1 week, I have been almost 10 days. I've had throat issues, cough or something, hence I didn't go live. Today I am a bit okay. So I thought of going live and answering some questions. There are many questions on the channel that have come. I'll try to take them. First, the order of priority will be I'll take any live questions. Preference will be given to channel members. If not, any other subscribers is fine. And then any comments, questions on the channel. Also, throughout the live, I'll be giving different UK visa updates that we have received. Every 5 minutes or so, I'll try and put in one update, so try to stay throughout the live. Other things, so other viewers have benefited a lot from whatever lives I have been doing over a period of more than a year now, I think almost 2 years now. So people have saved considerable sums on immigration advice, fees, etc. Whatever yes, no answers, even those 10 seconds answers have helped a lot to many individuals as they write on the channel, and they have confirmed via different sources to me. Thirdly, try to stay till the end of the live. I'll be discussing some specific updates on e-visas, student visas, and the third one is the most common reason for skilled sponsor license refusal, as Home Office has confirmed to us. So these are three things that I will cover towards the end of the live. I'll be live maybe about 45 minutes or so approximately. So towards the end of the live, I will be covering important updates on e-visas, student visas, and the most common reason for sponsor license refusal. So that's what I will do, and throughout the live also I will keep on giving updates every 5-10 minutes or so. Also, important thing, this live is not for someone who does not want UK visa advice or updates. If you're not interested in UK immigration, maybe you should drop off from this live. I'm just trying to set expectations very clearly. Also in this live, I can only give brief answers to your questions. Maybe that's something that I can answer in 10 or 15 seconds. 10-15 seconds is quite a considerable time. Yeah, so that's what, if you are not interested in UK immigration, UK visas, you should drop off from the call. Thirdly, introducing myself. So this is where I'm coming. So I'm Sachin Sawant. I'm a UK immigration lawyer. I'm registered with the OISC at level 3. I do advocacy, I do appeals at tribunals, everything. So that is my qualification and experience. Experience is more than, I would say, 12 years now in UK immigration, and I have worked in other industries before. So that's about me. Now, to come to the crux of the matter, if anyone coming live, you can ask me questions. I will open the YouTube comment section and I will take answers from questions from there and address them. In the meanwhile, till I don't have any live questions. YouTube. Anyone coming live can ask their questions. So I'll take the order on the comments on the YouTube channel. I'll take in the order of receipt, which are received latest. The first one I have is from someone, Kumagiri. What happened if applicant changed employer as well as SOC code change, as dependent need to apply a new one, or they continued in same visa? I understood the question. I will explain it. It's not phrased properly. So it is a skilled worker visa, change of employment. If employer changing question, you're changing the employer. At the same time, your SOC code is also changing. They're going into a different job code. So does dependent also need to make a visa application? No, that is not required. I've clarified this several times. If the dependent already has valid extant leave permission as a dependent, they don't need to file along with the main applicant. The main applicant can change the employer at that point. At any point, they can be changing job codes or changing employers. That's perfectly fine. So that is the answer to that question. Dependent does not need to apply every time the main applicant is making an application to change employer or to change job code or whatever the change that is. The dependent's permission is dependent on a skilled worker. So it says dependent partner or dependent child. That remains the same. Doesn't matter. You can change n number of employers, n number of job codes with the same employer or other employers. Doesn't matter. Next question I have is from Mohammed. I got visa 4 years, 11 months. Is it okay? That question is on. So I will explain the question properly because I understood what the question is about. Skilled worker indefinite leave to remain. So that is one of my shorts where I have explained if you are short of some period of time on 5 years on your skilled worker, there are ways to sort it out. Let's say you're just 1 or 2 months short. So on that one, he has asked a question, Mohammed. He got a visa, so he got a skilled worker visa for 4 years and 11 months, not total 5 years. Whatever may be the reason, he might have paid slightly short or the dates put accordingly, start date, work end date, whatever the reason is. 4 years and 11 months is a reasonable time. I think that 1 month short can be worked out. I don't think he will have to file for an extension. There may be a solution towards the end. Considering the current rules, it may be fine. He may not be able to apply for ILR, but some application, then variation, or an ILR, and trying to buy time by delaying the biometrics if that is still in progress, or upload of documents. Something like that may be possible. 4 years and 11 months would be fine, in my opinion. So I have a live question from Babakar. Okay, thank you for becoming member, Babakar. Good night. Sir, processing times, any changes in the new year? I know which processing time you are asking. I know you have asked this question before. For the parent visa, if I'm not wrong, and you don't have current permission, it's still 12 months and ongoing. There is no standard processing time given by Home Office, so it is still the same. Sorry, nothing new on the processing time changes for the parent visas where you don't have current permission, you are an overstayer and you are applying. So I don't think there is any change from Home Office. It's still almost 12 months. They are quite loaded with applications, as I'm aware of. So next question I have on the channel is, hello sir, thank you so much. I'm a student, plan to visit the UK for 2 weeks. I have invitation from family member and he will be sponsoring only my accommodation. Okay, the question is about a visitor visa. So the individual, he is a student, plans to visit the UK for 2 weeks, but he is not working. As I assume, he's just a student, and an invitation from a family member. Invitation is not relevant. That is completely. I think case workers would give 0.1% weightage to that. So that invitation is, I'm ignoring that. It was sponsoring only my accommodation. It doesn't matter. They will always look at your own circumstances, financial ties mainly. And I use my uncle's bank statements, who is in my country, for financial evidence. It will be a difficult application. You're just a student. They will not believe that you will be leaving the UK. You can try it, but then considering your situation, there are very less reasons that you will go back. That's what the caseworker will always allege, and that's what it seems from your case. You don't have any job over there, you don't have your own funds. Okay, so 5 minutes up, I'll give an update. I'll answer this question. I'm doing a 5 minutes timer and I'm trying to give one update every 5 to 10 minutes or so. So just to complete this answer, using your uncle's bank statement is fine, but I don't think the caseworkers would give much weight to that. They will always focus on your own financial circumstances. Unless you have a job or something, it will be difficult for you to get a successful application. That is what my opinion is from experience. Okay, thank you very much, Babakar. Okay, so I have some updates written down over here. Okay, currently, Home Office has been some of the sponsor license applications, even if they are filed by priority, uh, sometimes Home Office does keep them on hold. this is what Home Office has confirmed to us. Sometimes they are investigating the key personnel, the authorizing officer mainly, who is listed on the application for some reason, either for money laundering or any other uh, criminal or other related activities which are not conducive for a sponsor license authorizing officer. So sometimes they are doing these investigations at the back end. Hence, some of these applications on sponsor license, they may not reply with anything. They will just say, we are processing the application, we cannot give you any update. So the problem with that, this is quite a vicious circle model. They don't want to inform the person that they are investigating that person only. Hence, Home Office usually would reply. This happens with sponsor license applications where they are trying to investigate the key personnel. If a authorizing officer has signed off on a sponsor license, if they have any concerns about them for anything else, for example, money laundering, let's take an example, and they're trying to do their own internal checks to clear that person, see if there is an issue with that person. In that case, they may just reply blankly saying, your circumstances are complex, we need more time to consider the application. That's it, nothing else. And I know clients always want a reason why it is pending. They cannot give a reason. If they give the reason, they are themselves exposing themselves and telling them that we are investigating you. So this is one of the reasons that some of the sponsor license applications are getting delayed, that Home Office has confirmed to us. So this is one update. Let me set up another timer and then I will give the next update. Yes. So, hello, Benga. Yes, you can ask me a question. By the time I will take this question from the channel. So, question from Fatima Khan. I lost my BRP card. How can I apply for e-visa now? I've reported on the gov.uk website. So it very much depends where you are. If you don't have a BRP card and you are inside the UK, I think with your lost BRP, if you just have the details, to the best of my knowledge, you should be able to apply even with the details. If you just have a copy of it and you declare it as it is lost, I don't have it, but still there is a way to apply. I know that individuals have done it that way. And then if you don't have any copy, even a copy of that, then I think maybe you should speak to the helpline. There is a web chat for e-visas. If you Google search for it, it should come up. It says ask for help. If you go on the e-visa gov.uk page, at the end it says if you need any help, ask for help, then it directs you to the e-visa helpline. They should be able to help you with. If you are unable to use your BRP, you can definitely create your account with a passport also. I'm aware of this. I have created myself some of the e-visas accounts with passports and also with GWF numbers, application references and UANs. I have done it myself. So you may be able to use your unique application number if you have that for your latest application, or GWF uh, if you file the application outside the UK. So you can do that with application references, with passport also. Try all that. If that doesn't work, then go to that helpline. That's what my suggestion would be. But there is a way. Losing the BRP is not the end of the world. I know you can do it by passport, GWF reference, one way or the other. There is a way. Uh, okay, Benga, your live question is can one wait till January before you can apply for post-study visa? Can one wait till January before you apply for post-study visa? Sorry, I don't understand your question. Yeah, you can wait till January if you have valid permission. I don't know why January is relevant in your question. Uh, if you can explain your question, what is that you're trying to ask? You can wait till any month, but I don't know why you're asking specifically for January. You can apply in January, February, or whenever you want to. That is perfectly fine to apply for post-study work visa, provided you have current permission on the date of application. Okay, next question I have on the channel is Gul Rahil. Hello sir, I want your kind advice. I started the job from August and my payslip shows no income tax deduction because 12,500 tax-free income. I apply for ILR on June. I ask if it affects on my case or not because. Okay, the question is about, I think the question has been asked on how to meet UK spouse visa or partner visa financial requirements. So I'm assuming you're talking of either that 18,600 or 29,000, whichever rules you fall under. So your question is, I want your kind advice. I start the job in August. My payslip shows that no income tax deduction, 12,500 is tax-free income. Yes, you can use that. So I think the question is on your payslip, there is no tax deduction because you are within the annual allowance of 12,500. So you can use that income if your payslip shows no tax. That is correct. Obviously, you have earned within the limits. But I think you are trying to mix this income with some other income, then it should be fine because 12,500 will not meet the financial requirement, either the old one or the new one. So I think if you are combining it with any other income, partner's income, savings, or something else, you can still use those pay slips and use that part of the financial requirement, 12,500 that you earned, but there is no tax on the pay slips. That's perfectly fine. That's as per this HMRC rules that you are not taxed because you are within the personal allowance per year. So next question, live I have Azra. Can a dependent skilled worker extend visa from outside the country? What is the timeline? Can a dependent skilled worker extend from outside the country? No, you cannot extend from outside the country to the best of my knowledge. You have to be inside the UK to extend, and you should have valid permission on the date of application. That is very, very important. You cannot extend outside the UK. So Benga has clarified my student route visa ends on 17th of January. Having replaced my BRP with e-visa, can I apply for my post-study in January? Yes. Um, so you have already applied for your e-visa. So I don't care whether you have physical card or you have digital status. So your permission is valid till 17th of January 2025. That's what you confirm. The last day to submit your graduate route application is 17th of January 2025. That's the end of your student route permission. So you can file it in January. That's fine. Paul Sebastian, how to contact you for immigration advice? I'm currently with skilled worker visa where I mistakenly worked for a day as factory worker. So I am in need of advice to prepare for ILR. In the description of this live also you will have a link to book the consultation or on the channel information. Definitely in this live also there in the description you should have it. Once it is saved you will find it, or I think now also I'm not sure if you can find it now, but once the live is saved you will find it, or any other video also latest ones you should have in the description of those videos. You should have a link to book the consultation, so you can book the consultation through that link. Okay, so let me take next question. So no live questions for now. I have received this email last month, 60 days notice. Can you give me reference from office for this news as people care workers are still receiving emails? Okay, so this is a question on care worker visa update. The video I've made, sponsor license revoked, don't panic. So in that one, home office has definitely confirmed, and I know I've got the latest update last week also, which is a repeat update. I'll take the live question. Okay, so thank you. Can I please have your phone contact for the other advice in future? For other advice in future, usually, yeah, we don't provide any free advice. Sorry about that. All the If you want to book a paid consultation, the link should be in the description of this video or any other latest videos. There is a link to book the consultation, or in the channel information also there is a link to the website. So you can book any advice sessions through that. Okay, thank you very much, Paul. You can book it through. And one more thing, I am currently out of the UK. I'm on holiday. I'm working only early mornings and yeah, late nights. I'm just doing this live just to help out. Yeah, early mornings around 8 or 8:30. I think you may find some consultation options during the day. Yeah, I'm busy with family, but I am doing early morning. I am working 1 or 2 hours or so. So you will see only early morning sessions available for the consultations now till at least 8th of January. So, which is the question? So this question is on the care worker visa update. Yes, it is correct. Uh, you're asking me for the source. Yes, I'm a member of Immigration Lawyers Association. We have discussion with member managers and directors in home office, and they gave all this information. So I don't have anything in writing, but yes, we do discuss. We have all those questions. If you want to believe me or not. So I can't give you any. Home office is not going to give anything in writing because with the care worker situation, there a lot of fraud has happened. Home office has been, I know previously they have been revoking leaves and permissions and all of that because of no fault of the worker. But now in the last 6 months, home office is trying to work out with the Department of Social Services and other departments to see what is the problem they're trying to resolve. They are not curtailing permissions. I know that for a fact because on the channel at least 10 people have confirmed to me that Home Office has written to them saying sponsor license is revoked and we will write to you. So what they are trying to say is you have time, in other words. So at least they are allowing you, they are not curtailing. They have the right to curtail it immediately as soon as the sponsor license is. So I know for a fact that this is happening. Home Office has told us this, that they are not curtailing permissions of care workers whose sponsors have lost their license for whatever reasons, because that is not the fault of the worker. It is for a fact. And secondly, on the channel, I know at least 10 people have commented saying that they have got a email from home office saying sponsor license has been cancelled and we will write to you in due course. So that's what they mean is we are not cancelling at this point. They are not doing anything on the worker by themselves. So your question, I don't have any reference, but this is what Home Office updates us on our calls and all. Nothing in writing, but this is what is happening. I know it for a fact. Uh, and if you have received the 60 days notice of cancellation, I am sure Home Office has also confirmed that if there is any wrongdoing, that they have any doubt of wrongdoing on the part of the worker as well. For example, buying and selling of visas. It was very common in the last 2 years. Thousands and thousands of these care worker visas have been bought by people. I know that all over the world. I have been making various videos over the last 1 year, 2 year, I don't know, for a long time, informing people not to buy these visas. But I know people have bought this. Home Office knows this. We know this. Everyone knows this. So if Home Office knows that, okay, time is up. I'll give another update. Let me complete this one. So if Home Office knows that there is some wrongdoing on your part, you have bought or sold whatever, you are involved in some kind of a fraud of buying visas and all of that stuff, they are going to curtail it. They are not going to give, just because you're a care worker, they are not going to. If they have some evidence, even some evidence, one piece of evidence that some wrongdoing has been done or wrongdoing has been done from the on the part of the applicant, they will cancel the visa. I can guarantee you that. They are not going to give you the chance of not curtailing, which they are giving it to genuine candidates who don't have work because they are not a part of the fraud. They have been duped to some things. So I know Home Office may have some issues, whatever that is. That's why they may have curtailed your leave, but by default, Home Office is not curtailing. I know that for a fact. So okay, I have some live questions. Let me take them. Okay, so Asra, is there priority service for skilled workers dependent extension? Yes, it should be. I'm not able to find. It should be. If you are filing inside the UK, I know we have done many, I am pretty sure. Skilled worker dependents who is filing by themselves, you should find a priority and a super priority. But not from outside the UK. You will not get that. There is a problem with that. So oh, I know what the problem is. Outside the UK, if only the dependent is applying, you may not have the priority service option. There is a different problem to that. So I know the problem from Home Office. But inside UK, yes, it is possible. I hope there will be no further increment on the post-study, no further increment on post-study visa for now. No changes to the post-study visa to the best of my update as of today. I'm going to apply FCB UK for ILR a 10-year stay. Currently, I am on appendix private life or family road. 7 year with non-UK born children applying for ILR. Okay, I think your question will continue. Do I need to have an employer letter for future work confirmation? If you're applying for ILR on 10-year route, I don't think you need any employer's letter because the basis of the 10-year route is that you are not meeting the financial requirement. And even at the point of ILR, you are not expected to meet the financial requirement. Yes, you are not. But if you have any financial resources, savings, anything that you have, definitely show it to them, whatever income sources you have. But yeah, I don't think the rules require you to show that. Yeah, so that is my answer to that. Pawan Sai Chinta, so my visa reduced because I couldn't secure my placement right now. My e-visa still showing details before reduction. Haven't received any updates from Home Office. If your visa is reduced, what you mean by that would be it's curtailed to end on a whatever specific date, 60 days from today or something like that. So usually the e-visa, your e-visa screen backend should definitely change. I've seen that because I know students who have been curtailed. I know skilled workers who have been curtailed. If they have, let's say, 3 years of permission remaining and today they curtail it, their permission ends within 60 days and the e-visa does change. I'm not sure what is happening in your case. The backend, the digital status definitely changes. As soon as they send you that curtailment email, they change your end date for whatever is the reason. Your e-visa should change, but I'm not sure what is the thing with your thing. If maybe your e-visa has not been curtailed, I'm not sure how you got the information that your visa has been curtailed. Because if the e-visa, your digital status has not changed, I don't think your status can be changed any other way. That changes at the same time as soon as they issue the curtailment, cancellation, whatever email they issue. So maybe speak to an immigration lawyer. You can book a consultation with us or any other lawyer, discuss what the problem is, and take it from there. Do I need to have an employee letter? Future confirmation? No. Okay. Uni updated the home office. I completed the course early. Uni updated the home office. Completed the course early. If your e-visa has not cancelled, I don't think I am worried about it. So your e-visa does change. I know it for a fact. Anytime home office shortens your leave, it will change. Uh, yeah, I need to take all the details, all the facts of your case, why the visa is reduced. For the you couldn't secure a placement. Yeah, I know this placement issue is quite a common one that I have dealt with in the past. Uh, but then if they are but then if you completed the course of study without placement also, I think you may be eligible for graduate route. I'm not sure, but I think I've done something similar like this. Yeah, you may be eligible for a graduate route. I think you have completed the course of study. So if I'm not wrong, you have completed course of study which you confirm. So if you successfully completed, you may directly jump to the graduate route. I think I have done at least one such application in the last 1 year or so. Yeah, so I don't think you should worry, but then speak to an immigration lawyer and see there has to be some solution. Yeah, don't know exact facts of your case. So next, okay, next update. So my 10 minutes, I'll give another update now. So every 10 minutes, 5 to 10 minutes, I'll try and give an update. So the first one I gave this one, next one. Okay, so the main reason Home Office has clarified this, I know we were aware of this as lawyers, but then in general, all the post license queries for why there is a delay for undefined cost allocations. 18 weeks is the standard processing time. Priority service is almost next to impossible to get, only 60 slots in a day. Undefined certificate of sponsorship, why there is so much delay. So Home Office has clarified this. So all the post license queries go in the same bucket. So they have the same bucket where inbox or bucket where everything comes, all the changes, all the post license things. For example, change of address of the sponsor license, change of AO, change of authorizing officer, anything. So change of a legal representative, a lawyer like ourselves, all the changes go in the same box and so in the same bucket, and that is why the U cost also goes in the same bucket, and there are so many delays. Home office is trying to work, they have not yet, I know they have been promising this for more than a year. They're trying to work out maybe creating a different bucket for undefined cost allocations requests, but I think it has not happened. Maybe they are working with IT or so. They're thinking about it. But this is the problem. I know everyone asks me these questions. Why are there so many delays? Why is 18 weeks? This and that for undefined certificate of sponsorship allocations. The main reason is all the post license queries, all the post license changes. There are many types of changes that happen. They go in the same bucket. There are many changes that happen. We manage sponsor licenses. We report so many changes to sponsor licenses. I can understand how Home Office is inundated with so many post license queries. So UCOS also goes in that queue and sits in that queue only along with all other changes. And hence it takes 18 weeks, which is a standard processing time for any post license change of circumstances. So that is the reason for this is the second update I'm giving in this live. So I'll set up another timer and take up, let's see, I'll take the live question 1 minute. So start. Okay. Next question, next live, next update in 10 minutes. Okay, yeah, Pawan, you have completed the course of study. I think you should be fine. Speak to an immigration lawyer. I know exactly like this. I dealt with something around February, March of this year. Exactly similar. Could not get placement and all. I know you have that placement 1 year or something. They give extra on top of that permission. on the student permission. So you can speak to book a consultation with us, and I can advise you. I can go through the facts and advise you on the next steps, or you can go through any other immigration law. Your decision. Okay, Gokul. I have a receipt to write in Jan 15, but by the time the results are released, my visa would expire on Jan 18th, 15th, 18th. Okay. I'm planning to get PSW to work here. Can you help me with this problem? What is the solution? Yeah, if you see, there are some videos that I have made on the case studies for post-studies work with such situations where a reset and delay in results for any reason, whatever the reason is. Uh, so if you tell me when your results would be due, then I may be able to give you some help, some information on that. I need to know when your reset results will come out. I got these dates. I need the reset results, whatever is the tentative date. Then I can tell you yes and no. Free Albert, new entrant route will be eligible to work total 3 years. I completed 2 years PSW. You completed 2 years PSW, so you will get only 2 more years on the new entrant category. So 2 plus 2, that's it. Okay, next question on the channel. Your question, I applied for a few months but they didn't attend appointment. So Google results will be released in 3 weeks. So 3 weeks from you are writing it. 3 weeks should be fine. That's not a big deal. I have dealt with even situations where it was more than 6 weeks or so. I have sorted it out. So if you file it through an immigration law, you will need a lawyer because it's a validity concern. So this is the problem. I'll tell you the problem and then the solution, how it works out. So if you file, you have to file that graduate route application latest by the last date of your permission. That's it. There is no way you cannot do it after that. So it's out of time application. So your receipt is on 15th, your visa expires on 18th. So latest by 18th of January, you should submit your graduate route application. But if you submit it without the result, then that's a validity point. The application can be declared invalid. I know individuals have told me, where I've got to know from others where they have done it themselves, they've received refusals. I'm not sure what they done or they did it with someone. I don't know what happened, but I am aware that people have got refusals. But we have been doing, at least for last 2 years or so, I have been asking for pending applications. We regularly work with the case working. We explain them the problem. We give them the dates when we'll be providing. We've asked them to hold the application till we provide them the results, and up to a reasonable time. I cannot give the results after 6 months. I know they are not going to hold it for that long, for example. But yes, about 3-4 weeks, it's fine. It can be sorted. If you wish to file it through an immigration lawyer, I don't know which other immigration lawyers are doing this, but I know we have done this. I have myself done it several times. So if you wish, you can instruct us and we can represent you on the application and continue from there. For any information about consultation to start the process or just take an advice also, the link should be in the information, in the description of this video or any other videos, the latest ones. You will find the link to book the consultation. So you can start it from there and take the advice and decide if you wish to instruct us further, or you can speak to any other immigration lawyer who can help you out with this. But yes, with the facts that you have given, it is possible. I am not, but the important thing is you should pass. That is very, very important. You should get that pass email, pass confirmation from home office, from your university within those 3 to 4 weeks time. So that is important. Then we can help you. Yeah, thank you very much. Yeah, you can book it. And no live questions. Yeah, 3 weeks is fine. It can be sorted definitely. I've done more than that. Okay. So next question I have. So that is from a channel member on the channel, not live, but here. First, I have a question. Applied for FLR a few months ago, but I didn't attend the appointment. Few days back, received immigration bill notice. This is a common problem. I made that another video. Don't ruin your life filing FLR applications. People don't believe me. This is a live comment. It's on the channel. I'm just reading this comment from someone. Hello, sir. I have a question. I applied for FLR few months ago. He has done the FLR and he's ruined his situation. And he's just trying to buy time. I know he didn't attend the appointment. Some lawyers, someone may have advised, he may have read somewhere, delay buy time by dealing appointments, whatever that nonsense people try to do. But I didn't attend appointment, and few days back, even without the appointment, even before the validity stage, they have done it. I received immigration bail notice. They have straight away put him on immigration bail. I've explained details in the other video. Don't ruin your life with FLR application. You can watch that one. But this is what is happening, and this person is also asking that he received immigration bill notice. I never heard before attending appointment someone got a immigration bill notice. It's interesting to know. So Home Office is after these FLR applications which are filed frivolously. So please tell me for safety. I don't think you can do much. You receive the bail notice. You are anyways an overstay on the date. From the point you receive it, you should leave the UK unless you have any human rights basis. You have a genuine relationship of any British citizen, EU national who is living in the UK, or you are the parent of a British child or a child who has lived in the UK 7 years. Any human rights basis, unless you have that, you cannot continue living in the UK. You should leave the UK. So that is my advice. I cannot help you much here. So they suggest me to give a specific reason. So this is what the Home Office asked them. They put him on immigration bail. They suggested me to give a specific reason for your stay or either leave the UK. So that's what they will say. You are on bail, leave the UK. And I think you should leave the UK if that is what they have. You are an oversteer from that date forward. Now, for how I can check for how long they have given me immigration bail. There is no how long. Immigration bail is you are an overseer from that date forward. That's it. It is dangerous for your future. You should leave the UK in a reasonable time, preferably 14 days from the date of that if you want, if you're thinking of coming back to the UK on some other category. So I have answered all your questions. Okay. Live question I have. Who is that? Madheswaran, hi sir, I am now in healthcare visa, but I don't work there. Now I get job and costs with new employer. Can I change my visa? Yes, if you got the costs from another employer, you can change the visa. I don't think Home Office checks the previous employer, so I don't think they care much. So Emmanuel Belford, can I just inform the Home Office without a divorce certificate and my dependent will be given 60 days to leave the UK? Yes, I think without a divorce certificate also you can inform the Home Office. I know you are talking of reporting breakdown of relationship. Yes, you can report it. They are not going to ask you for a document. I don't think Home Office cares about that. If the sponsor has confirmed that I'm no longer in a relationship with this person, that's where they will take it on face value. But make sure you think before you report. I know many times clients come to me, they report, and then they make up and sort out the relationship, and then nothing can be done. Once the reporting is gone, once it's gone to that status review team, they start curtailing the permission of your partner and all. Nothing can be undone. A whole new application will have to be done. All the new fees will have to be paid. So remember, think before you are making the relationship breakdown reporting. So, but yes, and I'm on a care worker visa. Can I work in coffee shop part time? Is it legal? Making coffee is also a skill. I understand making coffee is a skill, but it is not on the list of skilled worker skilled occupations. So I doubt whether you will be able to do that job. I know people are doing that, many people are doing that, but they are in breach of their compliances. I know that many people are delivering food, I think, working in retail, wherever they are doing, whatever they are doing. But I would not advise. Home Office will come back to this because this is what Home Office does regularly. They release the rules. They did this with care worker visa. They did this with student visa. They will release it, they will watch for 2 years. After that, they will start beating up people on that, whatever. So they may not come back on with any problems, but I know after 2 or 3 years, they will come back at the point of ILR and start checking all these issues of breach of compliances. So my advice not to work in those jobs which are not on skilled occupations. In my case, can I apply for FLR and by time, sir, till results come? No, FLR is a big no. They are straight away putting people. I read a comment just now in this live only from someone else who has not even enrolled the biometrics. He's trying to delay by buying time on the biometrics. Even without that validity step, they have put him on immigration bail straight away. Even I don't know how they did that, but they are just catching people on that and putting them on bails. So, Yazid, okay, time for next. I'll take the live questions. Now it's 10 minutes up. Let me give another UKVI update. Third one I have here. What is this? Okay, pre-revenue costs. Okay, so this another big thing home office is catching up on. Yeah, they are working on preparing the guidance now. That's what they confirmed, I think, just 10 days back on the call. uh, Sponsor licenses, what is that? What is that everyone is selling on this TikTok and everywhere else? I don't know, lawyers or who is selling all this. uh, Self sponsorship, home office has caught up to that. They are going to beat up people on this. They have started refusing applications. Even genuine applications have been refused for this, I understand that, but let's not discuss that. But the point mainly is about all this self sponsorship. I know everyone advertises all over the world. It's in Dubai and UAE, everywhere people advertise. I think, I don't know who is doing this, agents and all. Home office has got to it. They have clearly said in the discussion that we had with them, it is not in the spirit of skilled worker visas. I understand what they mean. Whenever skilled worker visa was started, tier 2 general and all that stuff, when they started, it converted in the parliament, when it is put, when the rules are initially declared and it is put in the immigration rules, there is a, what do you call, an explanatory memorandum where they explain things. This is the intention of this visa, this is what it is. So that is the spirit of that visa. And all this self sponsorship game that is happening wherever it is happening, uh, it is not in the spirit. I understand what they mean. It is not in the spirit of skilled worker sponsorship, the intention with what the skilled worker was made. So they are catching up to it. They are refusing left, right, center every self sponsorship application. I know that for a fact. It's happening for about last 3 months or so, and hence several questions came from lawyers and we wrote to them. We tried to ask them, where is it in the guidance? Do you want to stop this? What are you refusing on this and that? So they said it is not in the spirit of skilled worker license. We are preparing the changes to the guidance. We will inform you in due course. So right now they are just doing the action and then they will bring it into the rules. Somehow they will do it in the guidance. So sponsor licensing is not in the rules, it's more in the guidance. So they will change the guidance accordingly. They're trying to see how to put it in the guidance. So yes, that is the latest one. These applications are being refused, almost 90% or almost all of them. I know, I heard from many lawyers, they have been refused, and even individuals self sponsorships are being getting refused. That is the next update. Let me set up another timer. Where is it gone? I will take the live questions. I know there are several of them. Start. Okay, let's take the questions. In my case, can I apply? No FLRs. Can we do? So, sir, can we do trading in UK on work permit? Trading is, I think, if it's a passive one, I think you can do that. I don't know how much that Robinhood takes time. I know I've heard, I don't know about Robinhood much, but if you are just passively putting money and through Vanguard or something, automatically it is going. You are spending 1 hour in a month, that's a different issue. But then if you are actively trading 2 hours in a day, if that is what Robinhood is, I don't know what Robinhood is. But yeah, it is mainly the way you have to think is, anytime you are doing any activity in the UK, it should not conflict with your, let's say you're contracted for 40 hours per week. You should be able to show that I was working 40 hours and in the night I was doing this 1 hour, whatever that is. So if you are able to justify that at the point of ILR, then you should be fine. Make sure you keep all the notes and all the proof what you were doing if that question is asked at the point of ILR. So, free Albert, from new entrant route visa to skilled worker visa, is it possible to switch? Yes, new entrant route is not a different route. Under skilled worker only, you have a discount for salary if you are applying as a new entrant. So there are two types of entrants: new entrant, experienced entrant. So if you are switching from graduate route, you can apply for up to 2 years of new entrant visa. At the end of the 2 years, you apply for further 3 years of, both are skilled worker visa only. So first you apply for 2 years skilled worker visa and say I am a new entrant under the new entrant category. Towards the end of that 2 years, in the last month, then you apply for further 3 years, that you are applying again on a skilled worker only, but as an experienced worker. So normal salaries apply. So both are skilled workers only. So 2 years of the new entrant category plus 3 years of the experienced category, total 5 years. You get ILR after 5 years. That's how you do. You can, yes, you are already on a skilled worker, so you're not switching on to a skilled worker. Terence Abhi, how long after a divorce can I apply for child dependent visa? Home office says application was done too soon after divorce. Too soon after divorce. What does that mean? I don't know, Home Office says, have you filed an application? It has been refused. I don't think there is any timeline how long after divorce you can do it. Provided you have, what are you applying? Can apply for child dependent visa. Child dependent. So you are the applicant after divorce can apply for child dependent visa. Yeah, if you can clarify your question, are you applying for the child or you are dependent on the child and the child is a British citizen? That's what you are trying to apply. I think you can apply as soon as you have the sole responsibility aspect of things. The divorce doesn't matter here. But then if you clarify, either you are applying as a dependent of the child who is a British citizen or settled in the UK, or the child is applying on you. I don't think child is applying, maybe you are applying. But yeah, please clarify that, then I can answer. But then I don't think date of divorce anyways matters. It's more the sole responsibility or the joint responsibility of the child that you may have. Emmanuel Belford. Once you reported to the Home Office for relation breakdown, how long will it take for the Home Office before the email? When that they, whenever Home Office picks it, I've seen Home Office picking it up within a month. Sometimes they don't pick up for, but I think in up to 6 months they definitely pick up. I've seen that. With relationship breakdown, they're quite fast nowadays. Definitely, I've seen 1 or 2 months definitely many times, but worst to worst, I think 6 months or so, for whatever reason, if they're busy with Christmas or anything. Yeah, so maybe 1 month to 6 months. That's what I would say when they would write to your the applicant that their permission has been curtailed. Mango Apple. What is the last date of for e-visa? There is no last date for e-visa. You can apply it anytime. You can even apply in January. So share as one while you are on one skilled worker visa. For how long can you stay outside UK without affecting your ILR if you go work from home? Yeah, that work from home is not relevant for Home Office ILR. They are considered concerned main with your absence from the UK. The rule applies the same 180 days. You can be outside the UK for a maximum of 180 days in any 12-month cycle, 12-month rolling cycle every day. That's what you have to count. Mango Apple, I'm on skilled work visa since last 6 months. Still, I did not apply for e-visa. Yeah, apply it as soon as possible. Maybe apply it after this call. You should. I really appreciate your work, sir. Thank you very much. Thank you, Emmanuel. Thank you. Do subscribe to the channel. Yes, I think you all are anyway subscribers. Maybe consider becoming a paid member. You get some early access to videos and some other stuff. Yeah, whatever that is, it's in that information thing. Uh, can I watch this live again? Yes, it is recorded. YouTube will save it, so you can watch it again. Jazib Shahzad, I heard about one lawyer. He asked me, sir, you have to maintain account by accountant because you pay tax on it. I am not sure. What is this relevance about? I don't know. Did you ask me anything, sir? Can you trading? Okay, trading in the UK. I have heard about one lawyer. He asked me, you have to maintain account by accountant because you pay tax on it. Paying taxes is just one aspect of it. That is more about HMRC. I think Home Office doesn't get into the HMRC fights with it. That's a different thing. If you are making money on it, you are definitely liable to pay tax. So that is the other side of it. But if you're asking me from immigration perspective, Home Office cares for ILR. They want to see if you contracted 40 hours on the skilled worker to work with your employer. Did you do that, or you were just doing that was just committed but not done, and this person was just trading on Robinhood for all the time. So that is what they care about. The tax aspect, anyways, HMRC will ask you to pay. You will need the accountant and all of that. That's an HMRC's game, not UKVI's game. And after 5 years, have we got ILR? Yeah, after 5 years, at towards the once you complete 5 years, in the last 28 days, you file for indefinite leave to remain application. The list of documents should be on our website, and there should be a video explaining the list of documents. The main document that you need is your latest payslip from your sponsor, latest bank statement showing that payment entry issued within 31 calendar days, both of them from the date of application, and a letter from employer confirming that we need Jazib Shehzad for the in this employment for the foreseeable future, and they confirm the SOC code, your salary, etc., etc. Those are the three main things. Other things are just life in the UK test, etc. But that is the main thing, the letter from the employer. Yes, Karen. So your application is refused. I'm assuming it is you are applying as a dependent on the child. Home office, yeah. The for refusals usually we need to look at the refusal reasons and only then I can advise you. But briefly, I understand what is happening. You have applied on the basis of a child, and you are the parent. I think you are applying for a parent visa, and but somewhere that sole responsibility or joint responsibility has not been proven. That's the summary of it. That's the reason why these applications are refused. I understand. But for your matter, usually speak to an immigration lawyer. You can book a paid consultation with us. Links are in the description, or speak to any other immigration lawyer. So, but yeah, the refusal needs to be reviewed. All the facts of the case needs to be set in what whether you meet the rules or not, or how to time your application, future application, or if there is any scope for appeal if you are still within the 14-day period of your refusal, etc. So if there are merits, you may also appeal and sort it out at a tribunal. So you can book a paid consultation with us and we can discuss and review the refusal reasons. What the best visa nowadays to keep the family in UK for study, to child? Sorry, I cannot advise on these best visas and all of that. I can only give general advice. You have to ask me specific questions about a specific visa category. I said, I'm a family of 4, husband, wife, 1 child born in India, come here, 1 year old, other. God, now Ayla, now we are 3 in private life. We 3 are in private life. Now I renewed in October. Can I get it? Sorry, I don't understand your question. I think you have private life permission. You are a family member 4. One for the child. Usually all the family members should be able to get the private life. If I think I am not getting your question, I'm a family of 4, husband, wife, 1 child born in India, come here at 1 year, other child born in the UK, and okay, so 2014. So you are getting it on the basis of the child born in the UK who has got the ILR. We 3 are in private life now. I renewed in October. Yeah, you can keep on renewing it. You will have to complete the 10 years period to get the ILR. That's what you will have to do. I know 1 child has got ILR on the basis of his own. He has spent anyways first 10 years of your life, or at least 7 years, and born in the UK. So he has ILR. You all are dependents on him. You'll have to continue till you complete 10 years uh, on that private life route. We are 3 in private life. Now I renew in October. Can I get it? Yes, you should be able to renew it. I don't see any issues with that. Hopefully, if the visa officer asks the uni whether the student completed the course, and then uni replies, student completed the course after his visa expired, will my visa? No, that is not anything. So if a caseworker has to refuse an application, the reasons they have to go through eligibility, validity, all the reasons that are written in the immigration rules. They can not just go with their own whims and wishes. So there is nothing written in the rules to that. Yeah, so they don't ask them. There is a proper channel how things are communicated. So yeah, that is not possible. Gokul, so I've answered that. Emmanuel, can you help me to the application for relationship breakdown? If yes, should I go about it? Relationship breakdown, there is a simple form. I'm not going to charge you for that. Just do a Google search, report relationship breakdown to UKVI, and that form comes up. You just fill it yourself. If you still want advice, maybe book a paid consultation with us, and then yeah, on the call I can guide you. So that's the way. But I'm not going to unnecessarily do any upselling over here. You can do it yourself. Try that yourself. If you are still struggling with that, maybe book a consultation, and on the live by screen sharing or something, I can help you fill that one. Yeah, I don't do that for visa applications, but this is a simple thing. Karen Zabi, how do I prove sole responsibility? I have the sole custody of the child. I'm on a skilled worker visa. Child was refused for submitting. Okay, child was refused. Let us see. So this is what another scenario. How do I prove sole responsibility? I have sole custody of the child. I'm on skilled worker visa. Child was refused for submitting father's consent. Submitting father's consent. That application was done soon after my divorce. So I think you are referring to an entry clearance application here. I'm pretty sure the child is not in the UK. So for this one, you really need to speak to a lawyer and get the refusal reasons. What is the problem that they have with the immigration rules? So we have to match up with the immigration rules and advise you accordingly. I may not be able to advise. Sole responsibility and all these matters are quite complicated. We need to take all the details and facts properly. Yeah, we can book a paid consultation with us. We can review the refusal reasons and advise you accordingly what is possible, what is not, or when it is possible. So, Shera Safwan, as a skilled worker, can I get my dependent to UK with an as a skilled worker? Can I get my dependent to UK with the new entrant salary bracket? So dependent. Yes, you can. There is no restriction on. I know this is some mix-up that happens. I don't know why people complicate matters. The dependents not allowed is only on two job codes. I think that is 6135 and 6136, if I'm not wrong. Care worker and senior care worker. The new entrant category, PhD, occupation, skilled worker, experience doesn't matter. If you are a skilled worker, you can sponsor your dependent. So if you are on a new entrant salary, it doesn't matter. You can sponsor. Only if you are in any of those job codes, 6135 and 6136, I think those care worker job codes, then you cannot sponsor a dependent. Those job dependents are not allowed on those job codes. A new entrant can sponsor, that's fine. Thanks Jajib. Maulik, I am business immigration paralegal. I am big fan of our, I think your videos, you mean posting information. Thank you very much, Maulik. Thank you. I hope it helps. I know many other some of the people are giving all these immigration exams, and they have also approached me, and that's why I'm trying to also, I've made some that skilled worker visa guide. I'm trying to make some videos on that board format so they can use it for their exams, and also, and I've kept them all the non-member section on open section, not on the paid sections and all of that. So yeah, if you, it helps you with any knowledge, exams, paralegal or whatever exams you're giving, yes, that's very good. Emmanuel Bedford, I'm overworking on a skilled worker visa. I worked my 40 hours with my company and I work 40 hours else. Where will I have any issues with my ILR? Yes, I would not advise doing that. I think there is some work time regulations. Google search for that, work time regulations. You will find it out. I think up to 60 may be reasonable, but beyond that may not be reasonable. Just check that. Uh, it's not good for your health anyways, but yes, home office may have issues if you're working 80 hours and that gets reported through HMRC in some way, taxes, payrolls, and all of that. If that comes to light, yes, it is not good for ILR. That's what I would say. Don't do that. Read that work time regulations in UK. Work time regulations. Pawan, completed my course early and my uni confirmed I'm eligible for PSW. They notified the home office after reduce my visa from 2 years to 1 year due to non-placement. Okay, understood. My Evisa still shows Jan 26 even after 5 months. The update hasn't been reflected. How should I resolve this issue? So if you want, do you want the your visa to be curtailed by that 1 year? If you want to do that, there is nothing that you can do. I don't know why you want to do that. When home office gets to it, they will do it. So that's what I can tell you. If you want to apply for a graduate route, you can apply immediately. Then there is nothing, it's not stopping you from that. Even if that e-visa is showing you have 1 more year of visa left, whatever, that's not relevant. You can switch to the graduate route if you meet the graduate route requirements, which you said you did. So I don't know why you're worried about. I've never heard anyone asking me that they want that visa to be curtailed on that online system. Home office doesn't have time to deal with some things that they don't care much about, like in your case. So that's why they may not pick it up early. They may pick it up whenever it comes to. They didn't even care. I think they are expecting you to apply for a graduate route, so they won't waste their time canceling that visa. But I don't know why you want that. You can go ahead and apply your PSW since you qualify on that front. How many days we have lived outside, if outside without effect to work visa? Yeah, you can, for ILR, in the 5-year period, qualifying period of ILR, you cannot be outside for more than 180 days in any 12-month cycle. Any means continuous 12-month cycle. It's a cumulative rolling cycle, month to month, day to day. So Camille, can my first child who come here in 1 year also need to complete 10 year in stationary? I think for that child, 5 years may be enough, but take proper immigration advice on his case. Home Office makes a lot of mistakes on these private life areas. But in my opinion, I'm pretty sure that child should be completing in 5 years. Maybe there is some concession going on. That child may complete in 5 years. I think that's what my understanding is. But get the facts verified through an immigration lawyer. Get proper advice. But my first instinct is yes, that child can get in 5 years. I have that. You completed first 2.5 years, applied for second 2.5. Yeah, understood. Someone asked 28 days, asked 180 days, which one is real? Please confirm that. Yeah, it's 180 days in any 12-month cycle. That's what maximum you can stay outside the UK. Gokul, in the eligibility criteria, it shows that student should apply for graduate visa before his student visa expires. Yes, that is correct. Shera Safwan, thank you so much for your valuable information. Thank you, Shera. Youth, anyone joining live, if you're getting any value in this live, do consider becoming a paid member. It's just 1 or 2 quid. Most of it goes in donations, I know that. So okay, time for another update. Let me pick up my update page. So every 10 minutes I'm giving an update from home office. What is that? Please make companies. This one I'm covering at the end. Yourself. Okay, so this is the latest things. Special applications are being refused since they are. Genuine vacancy. Many sponsor license applications are refused. So tier 1 entrepreneur, which is the old one, if people know about it, that was closed long time back, and some people are still on that route and they are coming towards the ILR. And there are some strict requirements of business creation, employment creation, and all of that, which was there in under those rules. And what people are trying to do, this is what Home Office has observed. If they are not meeting the ILR requirements, which is whatever 12 employment or 6 employments you have to create, some specific volume of turnover, all whatever the reasons, whatever the requirements were to meet the to qualify for ILR as a tier 1 entrepreneur, which is the old rules visa. It is not there currently live, but people who are coming towards the ILR and they are not meeting those, and they are trying to apply for self-sponsorship visas. So this is also, Home Office has observed this and they are refusing these applications. Anyone on tier 1 entrepreneur trying to apply for a sponsor license to self-sponsor themselves, they are refusing those applications left, right and center. So this is another update I have from Home Office. They have confirmed, we are aware that individuals who cannot meet the ILR requirements under the tier 1 entrepreneur route, they are trying to file these self-sponsorship applications to switch on to the skilled worker category so that they continue living in the UK and then qualify for ILR. And Home Office has got on grips to it. They have observed this and the reason mainly they are coming up with is for genuine vacancy. That is the only reason they are refusing it. There is no genuine vacancy in your business, whatever sponsor license you are trying to apply. It is a common one. Almost most of them are refused. I know that. Tier 1 entrepreneurs trying to self-sponsor themselves through their own companies, whatever they have set up on genuine vacancy, their applications for skilled sponsor license have been refused. So that is the another update. Let me set up another timer for the next update. Yes, let's do. Okay, start. Let me take some live questions. Yeah, okay. Jazib has done. Eligibility, Saraf, youth. UPS. My name on the BRP card and EQR don't match. When I link my BRP to Evisa, it shows like that. Actually, in the UK, our account details is correct and wrong in the BRP. I can convert to the Evisa, not here. Okay, all these Evisa, whatever these issues are, names and all that, there is a web chat with Home Office. If you search for UKVI Evisa, under that, when you have the last section of help, I think, what is the section? Let me just find it. Okay, web chat. I'm searching. I'll tell you what I'm searching exactly. So I'm searching web chat for e-visa UK. I'm not even in the UK, so still outside UK, it's still giving me this search. and then the gov.uk page comes as online immigration status brackets e-visa. That is the page. Under that, what is an e-visa? All those tabs come up. The last tab is if you need help. If you click on that, then if you need help, you can ask for help. If you click on that ask for help, it will ask you some questions and direct to a web chat. The web chat is 24 hours monitored by Home Office and by live agents to the best of my knowledge. You will have to contact through that, tell them the problem, they may be able to help you out with that issue. Any visa related issues, unable to create it, cannot see visa, whatever the issue is, name issues, all that stuff, you have to deal with this web chat only. They don't deal with any phone inquiries. I am sure about it. Home Office has confirmed that. The web chat is quite helpful. It is monitored 24 hours. Home Office confirmed they are dealing, and they do provide answers on that. I know that they try to solve it out for you. So that is the only thing I can tell you. So it's a web chat, you chat with them. So Imran Tanveer, brother, I need 5-6 months more after the PSL expires. What is the best application? Sorry, I cannot advise you just making frivolous applications. I don't do that. Emmanuel, next week I will book a consultation so you can help me with the relationship breakdown application. Yes, Emmanuel, you can do that. Thank you very much. Muthamil, when I am on a discretionary leave, 10 years road, how many days in a year can I travel outside the UK? Can I go back to home every 45 days? Overall, even on the discretionary route, if you're trying to play, I think to be on a safer side, the 182-day rules you should also follow. There is nothing in the rules on the private life, but yes, 182 rules has come up. So to be on a safer side, I think you cannot be outside. That's what you should follow. 180 days in any 12-month cycle. You should not. You can be outside the UK for up to 180 days. I don't think it is written, but to be on a safer side, this is what I would advise, to be only outside the UK up to 180 days in any 12 months period, any 12-month rolling period. If ILR got rejected once, does the individual could get one later? Yes, if they do qualify on the later one. Uh, it depends on if they are eligible and if they meet all the requirements, they may, but I'm not sure if it is back to back. What is that your question is you're trying to ask? Okay, good evening. I have pre-sale status. He question about e-visa. I have a biometric residence card. I tried uploading it on the ID checker app, but it shows the wrong document upload. I have pre-sale status. E-visa residence card uploading on the. Okay, I understood. So you're trying to create your e-visa, but if you have EU settlement scheme status, you should already have a e-visa account. You should already have a UKVI account. If you have status under EUSS, whether pre-SS or SS, whatever the hell that is, so you already have an EUSS account, and that should be connected through your passport. You should try to log into that, yeah, or go to that helpline. I talked about the helpline just about 5 minutes ago. Just check on this video and you will get the information that I discussed. But you should already have an e-visa account. Uh, so UKVI account you already have, because when you filed that pre-sale status application, you created your UKVI account, and through that you filed that application. So you cannot create another e-visa account or UKVI account. So you use your passport to log in, and it will send you the codes to your phone number and all. That's how you log into that. Emmanuel Bedford, if your dependent report to the Home Office that the main sponsor is not working with this employer, skill work visa curtailed, I don't think that will happen. Home Office doesn't have time to take random things from everywhere, I think, and there is no proper channel also. They will go through the fraud team. It's a very difficult one. I don't think that's quite unlikely. Gokul, I'm sorry, if that's the eligibility criteria, then would I be eligible because my results and course completion would happen after my student visa expires. What is I can get my PSW? Is it possible? Yes, Home Office has been exercising their discretion when lawyers are filing this application. I think, Gokul, your question is about the results coming after your visa expiry. So I think whatever I discuss, that applies. They are taking a practical approach to it. They are not going strictly by the rules. Yeah. So, Gulam, automatic annual allocation renewal. What is the question? Hello, sir. If the ILR got rejected once, does chance getting the once again? I don't know what you mean. If you can file within 14 days another application if you meet the requirements, but I don't know what is the reason your ILR is being getting refused. That's where the matter is. For example, let's say you did not file, I don't know. It is a very case specific situation why your ILR would be refused and why you would suddenly start qualify. Why would so when it was refused you were ineligible, and suddenly how do you become eligible? So I need the facts of the case. Why? What is that we are talking about? Emmanuel Bedford, if you are on a 3 years local visa and you are overworking, can you renew your visa once it's expired after 3 years? I think renewal should be fine. I don't think at renewal there is any checks like that. As for eligibility criteria, I should complete my course before completing. Student visa expires, but I won't happen in my case. So if I'm was inquire, yeah, they don't inquire so quickly, Gokul. That's what I'm trying to say. They try to take a practical approach. They just don't go. They don't have time to go on your case. They have thousands and thousands of applications to deal with. They just don't go and ask universities about your applications. There is a proper channel where the university conveys them, and they are trying to take a practical approach. They are not restricting themselves to that. They are taking whatever explanations we are providing. They are being reasonable with us. But I know individuals have filed and they have refused their applications. I know this for a fact also, because it is a validity reason. Application is invalid without successful completion on the date of application. But with lawyers, they have been reasonable. They have taken our explanations all the time. And how long is the decision made after an administrative review is filed? Usually successful. Admin review is not, doesn't have much merits. It will take up to 12 months or so. It will take a lot of time. Admin reviews is a general queue. It's a very big queue. Currently, I think they are working with 12 months or so. So it may take up to 12 months just for the admin review. And don't expect much from admin review. So what does administrative review mean? If I'm the case worker, I've refused your application. My colleague sitting next to me, Mr. X, he's another caseworker. He will pick up the application. He will check if I have done anything wrong in refusing the application. It doesn't have much merits. Admin review is only successful in cases where, for example, you submitted a bank statement and I did not look at it. I'm just talking, or you passed, you gave an English test certificate, but I did not see it and I refused it on that, for example. It's mainly administrative errors. That's the reason the name is admin review. So don't expect on your case about that. I doubt whether admin review would have any chances of success about the sole responsibility and all of that. So Emmanuel for any reason after 5 years on a visa you did not qualify for ILR, can you just keep renewing continuously till you get to 10 years in the UK apply for citizenship? Yeah, I don't think you can apply after 10 years. You cannot apply for 10 years citizenship. I don't know where you get that. It is a different thing what you are mixing up with. After 10 years you can apply long residence ILR. That's a different thing, provided you meet those requirements. But yes, I think you can keep on extending. There is no restriction on the intercompany, on the senior specialist worker GBM, Global Business Mobility. There is a 6 month and 9 month, 6 year and 9 year restriction. On the skilled worker, there is no restriction. You can keep on extending. Yes, I have got an accountant. Okay, you have got an account. I'm not sure. Yes, you have an account, so you have to access through that account only. If I think there's a pre-settled status login UKVI account you're talking of, you will not be able to create a separate e-visa. That is your e-visa through your EU settlement scheme login. Once I continuation of my previous condition, notify the office on October 8 that I completed my course early and I am eligible. Still apply obviously within 4 months from 30th October. Within 4 months from 30th October. Yes, you can. I don't think there is any problem. 30th, yes, you can, but this is not immigration advice. I'm just trying to give brief answers. I cannot be held responsible for this. I need to take all the facts to confirm advice on your matter. It's a very case specific. You should book a paid consultation. Only then I can confirm my advice. Yeah, that's one. I know applications can lead to refusal by my yes and no, so I don't want to commit to that. With Pawan, yes, you should book a paid consultation. I can answer that question, and that can be taken as immigration advice. Another question about my anytime there is dates in question, I cannot confirm that. With dates, a lot of mistakes happen. Individuals' applications get refused. I know that. I'm not going to confirm dates, months over year. I'm sorry about this. I can only give generic immigration advice. About my pre-settled status, I have been out of the country for 11 months for genuine reason, and I completed 5 years this month from the time I entered the UK. 5 months, 5 years this month. 11 months I have been out of the UK country for 11 months for genuine reason. Yeah, whatever that genuine reason is, it should come under the specific reasons that they have given you the options. Either there is a specific list of reasons. If it is coming under that, yes, that will be excluded. But if it is not under those reasons, yeah, for whether that 11 months of absence comes under those allowed reasons, you should speak to an immigration lawyer. You can book a consultation with us and we can review what proof you have to prove about those 11 months of absence from the UK. Without that, Home Office is not going to take just your word for it. You need to give some evidence of it. Just your word will not be accepted. So important things, speak to an immigration lawyer or book a consultation with us. My brother overstay 7 months. Did he have ban on him because he has new visa? 7 months overstay, yes. I think more than 3 months when you overstay, to the best of my knowledge, and you left at your own expense, minimum 1 year ban from the date you left the UK. 1 year ban. Mudamil, how long does it take for my discretionary leave renewal? I applied in October, still haven't result. Discretionary renewal, I think you will go under that one. You applied standard. I think it is 12 months and ongoing. That's what I answered to Babakar, the first question from a member. There is no standard decision time from Home Office, but at this point they are processing about 12 months. Applications filed and biometrics enrolled 12 months before. So at least 12 months, I would say. So what is the time? How long have I been live now? 76 minutes. Okay. So I will come towards the end of this live. I had promised whoever stays till the end of the live, I will be covering 3 points. I have it in my notes. I won't take any new questions. So there are 3 points that I had promised that I will deliver on whoever stays throughout the live. So let me answer those. As I promised, I will be sharing 3 important updates. One, e-visas. So on the e-visas, expired BRP cards, BRC cards can be used till 31st of March 2025. Home Office has confirmed that. So even if you are entering the UK from any country, you can show that expired BRP card, which will say 31st December 2024. Let's say you are boarding the flight on 1st of February, for example. So till 31st of March 2025, there is a 3-month grace period allowed. It's not, nothing is changing. E-visa, everything is continuing the same. Just a grace period has been allowed for carriers, for individuals to, if things have been messed up here and there, where you can show even your expired BRP and the carrier will allow you the flight, whichever carrier you are having, British Airways, anything, they will allow you to board the flight and come to the UK. One important caveat over here, your permission should be valid. So just having the card, let's say your 31st December 2024, your card is expired, but you don't have permission. Your permission is also expired. It, if you come to the UK using that card, you will be denied entry. You will be returned back. You will be sent back. You won't be allowed to enter the UK. When the immigration officer will check you, when they allow you entry, they will see you don't have any permission. So this discretion is only for people who have permission, valid permission, which is beyond the date of you entering the UK, and you don't have the physical card. So whatever is the reason, you didn't create the e-visa, your e-visa is not working, any issues with the e-visa thing, the name things, whatever we discussed, some people ask me here on the channel and all. So if those are the problems, yes, those, for that the government has given this discretion till 31st of March 2025, 3 months after the expiry of all the BRP cards and all of that, the carriers will still allow you to board the flights. That's number one. The second point that I promised it is on the student visa front. So there is some latest update that has come. It's not very clear how it is going to happen. The student agents. So last 1 year, I think I had some updates 6 months before. Home Office said we are going to crack down on the agents. There are many frivolous agents who sell all these promises of courses. You will come to the UK, you will have a better life, you will get skilled worker visa, you will get everything, your life will be changed. They migrate these individuals on student visas by making all these fake promises wherever in the world, saying that you are migrating on the student visa and your life will be sorted, whatever that is. So Home Office is going to tab on these. They are going to They had promised, I think 6 months ago in the news, they said we are going to catch all these frivolous, all these agents who are doing all these frauds, selling all these courses with the wrong promises or whatever they are doing. And now they have come up with a solution. So that time they said we will come up with a solution. They finally came up. They are saying now on the CAS itself they will mention the name of the agent. So if, for example, I am the agent, my name is Mr. X, and my name or my agency or whatever, something will be mentioned on the CAS letter, confirmation of acceptance for studies. The CAS letter that you get when you apply for a student visa, when you pay the fees. So I think this is how student visa work. You apply to the university through that agent, then the agent works, sends all your documents, and then they give you that offer letter. You pay the fees, and the CAS is given. On the CAS, no doubt the CAS will be issued by the university. It will also have the name of the agent. So they want to keep a tab, and over a period of time, they will collate this data, and then they will go after all these agents through universities or however they will do it. So they are at least they are starting an information gathering exercise. This is what Home Office always does. They start this information gathering exercise, and this is what they are doing on agents through the universities. So if an agent has referred a student to a particular university, they've got whatever their commissions are, then that agent's name will be reflected on that CAS, confirmation of acceptance for studies, which means Home Office will keep on maintaining that data, and later on whenever they want to catch those weird agents who are creating problems, they can easily research that information. So that is the goal of it. So this is another update. I promised three things. One is on e-visas, which I said. Second, student visa. This is going to happen. You will see the names of the agents at some point. They are going to start it. They are just trying to work it on the software part of things. Third thing, about the most common reason for sponsor license refusals. It's a very small thing for us lawyers, which we always check. We look at it, and I can tell you this is not correct. But with employers, many employers or most employers who apply for sponsor license, Home Office has confirmed this. Whenever they try to do either a digital audit or a physical audit, whatever they are trying to ask questions, they are trying to gather information before approving the sponsor license. The most common reason that they refuse this sponsor license application is that they see the right to work checks of the current employees have not been conducted properly. Forget about the sponsoring migrants and all. Currently, let's say the employer has 10 employees, for example, and now they want a sponsor license to hire one employee, for example. Then, when they go and check the documents that the employer is keeping for those 10 employees, they don't see proper right to work checks done, and that's where they straight away go and refuse the sponsor license application. You are not even meeting those right to work guidance requirements now. How do we expect you to do that in future? So this is a very common reason. It can be undone. I've myself, we've done many applications where employers have done this mistake. We have gone through the 6 month of cooling off period, sometimes refiled the applications and got it sorted by putting in place all the checks and controls in place. But this is a very common reason. So these are three updates I promised, and this is what I'm giving towards the end of this live. And if you do like this live, do like, subscribe to our channel, consider becoming a paid member. There are some questions, I will try to take them. Okay, let us see if I can try to do it. Okay. Okay, I've answered this. How long does it take for discretionary? Okay, Karen's I think last question. Can one be on a skilled worker visa and apply for asylum? Can I then continue to work for my skilled worker employer while on asylum? On a skilled worker visa, yes, if you have whatever the fear of persecution in your home country, whatever the reasons are, yes, you can apply. Application doesn't matter, you have all the process. You will have section 3C leave since you are on skilled worker, and you will apply. Yes, you can continue working. Your current permission will continue. Yeah, so your current permission will continue, so you will have section 3C leave. You can continue working with your employer and all. So yes, legally speaking, you will have a right to work, and your current rights will continue till your asylum application is decided. So yeah, that is fine. Okay, and thank you very much anyone who joined live. Do subscribe to our channel, book a paid consultation for your specific immigration advice. Information in the description of this live. I will do these lives. Yeah. Emmanuel, how long does it take to get a divorce if your partner refuses to accept? Sorry, I don't practice divorce law. I know mutual divorce takes about 6 months. I know that much. But for divorce law, just Google search for, there are some divorce companies in the UK. They should give you some timeline. Speak to them. I don't practice that area. So thank you. Sorry about that. And thank you very much who all joined this live.